Welcome back to Good Law, Bad Law. On today's episode, we're talking about a very controversial topic, sexual violence, sexual crimes, and the way our criminal justice system treats and handles perpetrators of sexual violence. Of course, there's something particularly heinous in our collective imagination about those who commit such crimes. How do we treat them? And more importantly, are we really serving the goal of preventing more sexual violence by means of the way we do treat perpetrators of sexual crimes? My guests on today's episode are two professors, scholars on this subject, Ira Ellman of the University of California at Berkeley, and Eric Janus, who is a professor of law at Hamline School of Law in St. Paul, Minnesota. We have quite the conversation. It is not that anybody is in any way defending or supporting those who commit these most heinous crimes. It's more a question of how do we have a system that meets the goals that we have? Or is our system based mainly on fear? To get at some of these tough questions and a really, really great, fascinating conversation, please stay tuned and also share your thoughts. We would love to hear what you think. You can do that on Twitter, on our new Facebook page, which I encourage you to visit and like. However you do it, let us know what you think and enjoy today's episode. I want to start today's conversation with a quote from an article co-written by one of my guests today, and I'll introduce them shortly. The quote goes like this: "Risk perception may not be about quantifiable risk so much as it is about immeasurable fear. When we encounter information that contradicts our beliefs, we tend to doubt the information, not ourselves." And there's a topic we have today that for sure inspires a lot of fear, but the science behind that fear is something else altogether. And that's what we're going to be talking about when it comes to criminal sex offenders and how the criminal law treats those crimes and those criminals, particularly once they have served time in prison. My guests today know an awful lot about this, and I'm really looking forward to talking with them on this subject. My guest, Ira Ellman, who is a distinguished affiliate scholar of the Center for the Study of Law and Society at the University of California, Berkeley, and also with the Berkeley Center for Child and Youth Policy, and Eric Janus, who is a professor of law at Hamline School of Law in Minnesota, in Minneapolis, and is also the former president and dean of William Mitchell College of Law, also the author of the book Failure to Protect: America's Sexual Predator Laws and the Rise of the Preventative State. I want to welcome both of you, Ira and Eric. Thank you so much for being on Good Law, Bad Law today.
Thanks.
Happy
Great
to be here.
Yeah.
So I have to say that I was so intrigued by this topic because two scholars such as yourselves writing about the rights of criminal sex offenders and how the law in our state courts and all the way up to the U.S. Supreme Court has based so much of its decisions when it comes to the way we treat sex offenders under the law appears to be so unfounded in fact, though it surely is founded in fear, which is why I thought that quote was so appropriate. Perhaps both of you, or one at a time, so we don't get confusion here, could just give us a little background on yourself and how you came to this topic and why you have, why you come to believe that this is so important, because it is certainly, I think, very little understood by most people. Ira, perhaps we could start with you. How did you come to this topic in your work and your research?
Well, it's kind of fortuitous in a way. I was on the verge of retirement from a position at Arizona State University, and I'd spent a life in family law and really had sort of tapped out. I'd spent 35 years writing and researching about it, and I really thought in my retirement I ought to move to something else to kind of reinvigorate my interests, and someone I knew got involved in this issue, and I started looking into it. And I have a background in psychology as well as in law, and it seemed to me there was an awful lot of assumptions that were being made that might not be right. And the more I got into it, the more impressed I was by how badly grounded all these assumptions that underlay legal policies were. They just were completely off. And so kind of the last piece I wrote while I was still officially employed is the one you just quoted from. And it was a brief article, but it got a lot of attention, in some ways
Yeah.
more than anything I'd written
Hmm.
in all the years doing family law. And that drew me in because people started wanting to talk to me about this, and
Hmm.
and then it kind of took off, and it's become my main topic that I've been working on.
And the central assumption in that piece, in this article, which I think came out in 2015, which is the basis for so many policies and court decisions, is this assumption, as you say, that there is a high recidivism rate or a high repeat offense rate among criminal sex offenders. And as you go on to talk about in the article, there's a lot of reason to suspect that assumption and a lot of data to actually cast doubt on that assumption. Eric, give us a little background on yourself, and also, as you do, perhaps you could also set us up to understand what are some of the ways in which the law imposes special burdens and restrictions on criminal sex offenders.
Yeah, well, I've actually been involved in this subject for almost 30 years. Going all the way back to the early 90s. I was a law professor at the time, but I had been a legal aid lawyer for the first decade of my law practice, and I had developed a specialty in mental health law, civil commitment. And then in the early 90s, a couple of states, Minnesota and Washington in particular, started using civil commitment to lock up sex offenders who had finished serving their sentences, locked them up in so-called treatment centers on the grounds that they were suspected to be present a continuing danger,
Mm.
and that offended my sense of justice because it seemed to be a very, very ill-defined intervention, and in my view, turned our normal American principles of that we don't have ex post facto laws, we don't extend punishments after a person is sentenced, and when your time in prison is up, you get out. And these so-called civil commitment laws were keeping people locked up after they had served their prison sentence. And so I got involved in litigating the constitutionality of the Minnesota sex offender commitment law, and that went on for a decade, but also introduced me to the social science and the policy. And I became, as the more I learned about it, the more I came to understand that those laws, as well as there are a set of other laws are that are kind of similar. They're based on faulty assumptions. They're based on fear, and they're bad policy. If they claim to have prevention as their purpose, but when you dig into them a little bit, you see that actually they're quite counterproductive.
Well, yeah, and tell us a little bit, because there are different categories of these restrictions, just so we have a sense of the playing field here.
Right. So there really are three categories of laws that we're talking about. What they all share in common is that they're all restrictions that are imposed on people who had been committed or convicted of a sexual offense, but they've all served their sentences, and so we're talking post-prison here. So three categories of laws. There's the civil commitment laws that I mentioned, and those actually lock people up physically, often for many years. There are about 6,000 people in the country now that are locked up in 20 different states under those sex offender civil commitment laws. Second category is registration and public notification. So these started as very simple laws saying that if you had served some time for a sex offense, you have to register with the police. They've now expanded. There are about 1 million people in the country who are registered, who are on these registries. In most cases, all of the names are public on websites, and it's very undifferentiated. It can be anywhere from a violent rapist to a 19-year-old who had a 15-year-old girlfriend. And then the third category we might call behavioral restrictions, and they range from residential, what we call banishment laws. If you're on the registry, you can't live in certain areas. Often
like
these
near a
banishment
school,
laws,
for instance.
near a school, a playground, a bus stop, and often these laws are so comprehensive that they exclude people altogether from a city. So they're the residential banishment laws, and then there's some other behavioral laws like, and these are more extreme, but you have to have a pink license plate, or you have to put a sign in front of your house that you're a sex offender on Halloween. Those kind of behavioral laws. So those are the three categories of law. They all share the feature that they are imposed on people after they've served their sentence, and they all claim not to be punishment. They all claim to be simply aimed at preventing future sex offending.
Maybe I'll
let me
jump in.
Let me just follow up.
Well,
yeah, go ahead, Ira. Sure.
Yeah, because I don't know if you want to call this a fourth category or a subcategory of the third one that Eric mentioned, but there are also laws that single out people who are on the registry for special treatment that other felons are not subjected to. So I'll just give a few examples. Florida recently adopted a law that now allows people who've served a felony prison sentence to vote, after all, once they've completed their probation. But anyone who's committed a sexual offense is excluded from that. They didn't get the right to vote back. Other felons did. The Federal Second Chance Act that was passed finally last year, the beginning, just beginning bites at reform of criminal justice reform. People who committed sexual offenses in the federal system, they're excluded. California recently has been trying to reduce its prison population because it got so totally out of hand. They're under federal court order, and so they're allowing some people to apply for parole if they're currently serving a nonviolent sentence, and they've already served the main sentence, but they haven't all the enhancements. But if they ever committed a sexual offense, they can't be considered for parole. The issue is not whether they get it; they can't even be considered.
Well, I want to come back to the underpinning of all of these regulations, and they have been challenged on constitutional grounds all the way to the Supreme Court. Ira, you talk about this in the article from 2015, and want to get to that, but to refer to these as punishments, sort of punishments after the punishment has already been given and the time has been served, I'm not sure people fully appreciate just how how consequential these punishments are. And I'm thinking particularly of the example that probably a lot of people will remember, which is the case of Brock Turner in California. We've talked about that on this program before. This was the Stanford student who allegedly sexually assault. Well, he was convicted of 2 counts of felony sexual assault of a woman. She's since come out with a book and is talking about her experiences. And there was a huge controversy over the sentence he received. So controversial that he only got a 6-month sentence, but was limited to the 3 months he served, I believe. It was so outraged the community in California that that voters recalled the judge who had handed down that sentence and basically threw him off the court. But the part that really stuck out to me and that I was thinking about in thinking about the conversation we were going to have today is that Brock Turner was, as a result of his convictions, um, required to be on a sex offender registry for the rest of his life, which I think is what the policy is in California. I mean, Garrett, can you, give us a sense of just how, what an impact these types of regulations have on people, and then people can decide whether they think it's deserved or not. I mean, there may be some people who will have the view, I don't care what kind of punishment we throw at them when they commit this kind of crime. For all I care, we can ship them off to Mars and never see them again. But and there may be people that would take that view. But these seem like extremely, extraordinarily rough punishments for people who will have already served an appropriately handed down criminal sentence in jail or in prison.
Yeah, for sure. I think we can begin by saying that there across the country there are a range of laws on registration and notification. Some states are more reasonable in a sense than others, but the main characteristic of them is that they're very broad. Once you're on probably forever. Very limited opportunity to demonstrate that you are not a risk and should come off. Your name is public. And then there are these other consequences for being on the registry. Your name is public, so there's been a fair amount of vigilantism. And then these other restrictions begin to apply. And those other restrictions not only affect the registrant, but often their family. So and I think that Ira can also speak to this, but in some states, the level of restriction that's imposed on people on the registry is severe. There are hundreds of rules that need to be followed, frequent visits to the police to register, restrictions on where the people can go, restrictions on where they can live. And again, those restrictions not only affect the individual, but also the family, the children of the individual, the spouse. And I think that the key here is, go ahead.
No, well, I was just going to say the Turner case is an interesting example because the judge actually said that one of the reasons when he explained the sentence that he gave what seemed to a lot of people to be a very short sentence for what he did, but the judge said one of the reasons is, well, he's going to be on the registry for the rest of his life. And that's going to be so punishing that, so the point is that, of course, if you didn't have that registry consequence, he probably would have gotten a longer sentence. And if you want to punish, that's the way we normally do punish. And I'll just observe, you can't underestimate the impact of being listed on that public website, the impact and being on the registry, the impact it has in your opportunity to get employment once you.
Yeah, that's what I was going to say.
And even housing. So it becomes really really difficult to get housing.
Well, and
It's
one of you
difficult
talked
already.
about this. It has to have a very isolating impact, and there's something
Yeah.
about this type of crime different. It seems from almost any other kind of crime that as a matter of the social policy or the social wish behind these rules and regulations is to isolate the person as much as
Hmm.
possible. If there was an option to ship them off to Mars, it seems like
Right.
many courts wouldn't have any real problem with that, because that would be the maximum isolation from the rest of society. Um, and so why is that? I mean, it almost seems obvious if you
Yeah.
think
I,
about it, but why, as a matter of law and as a matter of legal and social policy, is that the direction we've taken?
well, I think that goes to the underlying psychology here that people assume that anyone who's committed a sex offense, and the very term sex offender, seems to communicate to most people this is a person with a very serious flaw in their makeup that is nothing can be done about it. And they remain a threat forever because there's something really wrong with them. And they don't jump to that sort of conclusion necessarily about, a burglar, an armed robber, even a murderer. But they do have that instinctual reaction, it would seem. And as I say, the very label sex offender seems to be communicate to people a psychological diagnosis rather than a legal classification, which is all it really is. It means someone who's ever been convicted of one of these crimes, a long list of crimes. And that's
And
the mistaken view. That's the problem is that instinct lies behind a lot of these rules, and it's not based on good science. To the contrary.
Well, what is the science? I mean, it seems to me there has to be at this point some sociological, psychological, psychiatric science on this, that experts such as yourselves who mix law with other social sciences
Yeah.
ought to be able to draw on.
Well, I mean, one way to look at it, right, is to ask the question: how often, how likely are people to reoffend, right? And you can look at people who've committed a sexual offense and people who've committed non-sexual offenses, and ask that question: how likely
Mm-hmm.
are they to reoffend? And it turns out that the overall average rate for reoffending, you've got to have a period of time that you're looking at it, just because you're going to follow them up for 3 years, 5 years, 8 years, whatever. But for any given period of time, the actual rate of reoffending is not higher. In fact, it's lower
Mm-hmm.
than most other offenses. And indeed, it turns out that even people who, even if you just look at sexual offending, people who are released from prison for a felony that's not a sexual offense, among the things that some of them do when they commit another crime is a sexual offense. And so they have a rate of somewhere between 1% and 2% of committing a sexual offense, even though they never committed one in the past. And that's about the same as the rate of sexual reoffending of a lot of people who are on the registry, particularly when they've been out for a while and they haven't reoffended. And that's the best indicator of the likelihood they'll reoffend in the future. Have they reoffended so far? Every year they go without reoffending, that chance goes down, but the law doesn't take that into account. So it's just, there are individual differences. It's really important to understand that. This group of people that are all lumped together in this one gigantic category aren't all the same. And there are.
Well, yeah. Let me pause you there
Some of
because
them
that's
do have a high risk. Some of them
well,
do have a high risk.
Yeah,
But
that's a really great distinction. Let me pause you right there for just a minute because I want to understand because again, courts that have to hear disputes about these types of policies or restrictions, and they have been challenged in the courts at times, and in individual cases as well. They're not really looking at individual mental health status or mental health profiles. They're looking at a category of offenses called sexual crimes.
mhm.
And uh, I just want to make sure I understand this because I think this is really important. You and, in fact, both of you are among 19 uh, scholars and social scientists and legal experts who filed a brief in a California Supreme Court case called In re Gregory Gadlin. And I believe this case is still pending,
That's
in which
right. It's a current case. Yeah.
it's a current case, and you
Yeah.
cite data from the California Department of Corrections and Rehabilitation, California's own data on the rate of repeat offenders rather, and that's broken down into some categories. So you can look at the rate of reoffending among uh, non-sex offenders or those who have been convicted of non-sex crimes and those who have been convicted of sex crimes. And actually, when you look at that data and break it out as you do in this brief, the rate of repeat offending by those convicted of a sexual crime is lower than the general group of those who
Mhm.
are repeat offenders. So that would seem to fly in the face of this assumption, this big assumption that we talked about at the beginning, would seem to suggest if we're gearing these policies, whether it's geographic restrictions or registry requirements or denial of certain rights and privileges that other ex-felons get the benefit of once they've served their time, if we're basing that on this idea that sex crime perpetrators as a group have a higher rate of repeat offending, at least this set of data suggests strongly otherwise.
Yeah,
Yeah.
that's absolutely right. I think it would surprise a lot of people. Not only is the relative rate for sex offenders less than the rate for other kinds of crime, but the absolute rate is surprisingly, for many people, low. I mean,
Yeah.
if you look at the first 3 to 5 years that someone's out of prison, which is when, if there is going to be a reoffense, it's most likely to occur. Often those studies show single-digit recidivism
Mm.
compared to the kind of the myth that almost everybody who is convicted of a sex offense will commit another one. Again, these studies show that 95% of people do not commit another offense within the first 3 to 5 years that they've been released. And then you add to that, I mean, there's been actually a lot of research in this area. It's quite useful, and it would be useful for public policy to be based on some of the research. So A, you've got this fairly low relative recidivism rate. B, as Ira mentioned, the longer somebody stays out in the community without reoffending, the less likely they are in the future to reoffend. So it's not a lifetime risk. If you live safely for 5 to 10 years, your statistical risk is very low, almost indistinguishable from the background. And thirdly, as people get older, unsurprisingly, their risk decreases.
Well,
So you've got,
what about
yeah,
age? Isn't age also a factor in that?
yeah, that's what I
These are
mean. As
yeah.
people age,
Yes.
absolutely, the older a person is, the lower the risk of offending or reoffending. Right. So you've
Mm-hmm.
got all of those factors operating, and really to take the next step, when we design prevention policies, because that's after all, what all of these laws claim to be. They claim to be policies that are trying to prevent future offenses. It's foolish not to take into account the changes in risk, because that means if we don't take that into account as a society, we're putting our resources in the wrong place. And, the stories are legion. Just to take one example, if we're really concerned about sexual violence, why are there tens of thousands of rape kits around the country that are untested?
Yeah.
Well, it's a resource issue. And here we have an opportunity to more precisely design our policies around what the reality is. And for the most part, neither courts nor legislatures are interested in doing that.
So let me understand that. So you're saying, given the actual data on reoffending, we'd be better off spending some of the dollars we're spending on restricting those who are at very low risk of reoffending. We'd be better off spending those dollars on testing those untested rape kits and catching other sexual violence perpetrators.
Absolutely. I mean, that's just one example. I mean, there's a lot of examples of prevention programs that are tried and true that are going wanting because we don't have the resources. And I'm talking about sexual violence prevention, domestic violence prevention, that are not flashy. So they don't have the same allure, perhaps, as these ritual exile, we're keeping the people away from us in a very visible way. But they would actually have very beneficial effects if we put adequate resources into them.
So part of the concern I'm hearing is that we should, as a matter of principle, as a matter of believers in the most fundamental rules of fairness and justice, something should offend us about punishing somebody based on the fear of what that person might do in the future, where based on social science, there actually is a very low risk of that person committing some future bad act. But also, we of course live in the real world where there are limited resources, and there could, as you just pointed out with that example, we could use resources better to actually. Somebody's phone is ringing.
Yeah, it's not mine.
But we keep it real on Good Law, Bad Law. That's okay.
Okay. Sorry about that.
That's okay. That's okay. But part of it is that if we do believe in punishing those who commit bad acts of sexual violence, then we ought to devote the resources in the best way possible to affect that goal in the best way we can. This isn't about doing special favors for those who commit some of the most heinous criminal acts. It's really about, bringing some semblance of order to a system and not having it be guided by irrational grounds.
Yeah. I would.
Go ahead, Ira.
Yeah. Well, I was just going to observe that the cost of the registration system, for example, it's very significant, and the numbers keep increasing if you keep people on forever. So the other day, I'll just give an example. I mean, somebody that I know who's a registrant. I do this work, so I know people who'd never violated anything since he's been out in the community, employed, whatever. 4 Alameda County sheriffs in full SWAT gear show up for no particular reason, just as a compliance check. Does he really live in the house that he has listed that he lives in, I guess, is what they were looking for. There was no reason to doubt that he had. You have to go back and register all the time. They could see that his car parked in front that was, and so they had 4 of these people spending probably 45 minutes or an hour, four cops doing this. And of course, while they're doing it, all the neighbors are noticing, and so there's obviously an incredible embarrassment to the registries. Those people could have been doing something else that would have been more useful in crime fighting.
Well, let me come back to the point that I promised I'd come back to, Ira, that you were making earlier, which is rather than looking at sex crimes as a broad category, and it may be more broadly defined in some places than in others, and everyone who is a perpetrator of such a crime being treated in some of these very extraordinary ways, can the law and social science together look at people on an individualized basis? I mean, we do this in other areas of law. We do this, for example, in making parole determinations. We do this in sentencing. I mean, we don't, sentencing guidelines may have gotten in the way of more individualized sentencing by judges, and many are critical of sentencing guidelines for that reason. But there are ways in which our system does look at the individual. Does this person meet a certain mental illness profile or psychological profile? I mean, why can't we look at people on an individualized basis in determining what extra steps need to be taken beyond a person's prison term?
Well, we can, and in fact, there's been an awful lot of research that's been done establishing ways by which to predict the level of risk for these people on an individual basis. And you can separate out those who pose a higher risk and those who pose a lower risk. And it's not very difficult to do. The Canadian government has employed researchers who devised what's around the world probably the most frequently used simple actuarial test that sorts people. You know, it's not perfect, but it's pretty good. And once you start out with that, then the next step is to just say, well, let's see what happens. As Eric was saying, the longer they're out without reoffending, the lower chance that they will. And if they start out at a low risk, they reach a point of, desistance. They're just, the likelihood of their reoffending is just too low to take any notice of. They can reach that point pretty quickly if they start out in this low risk category. Even if they're in a high risk category, if they go 10, 15 years at liberty and they've not reoffended, you really have to reassess that risk category. They're really not high risk people at that point. A case in Oregon I'm involved in right now, there's a guy who was originally, I think, reasonably regarded as high risk. But he hasn't committed, it's been over 20 years, he's been at liberty without committing any offense. He's about to turn 70 years old, but Oregon still wants to classify him as high risk. That makes no sense.
Eric, let me ask you this then. Can you make the argument when you're looking at rates of recidivism for these offenders who have over their heads certain extraordinary restrictions that typically don't apply to other types of criminal offenders? Couldn't it be argued that those extra measures do serve a preventative purpose? And the proof of that is the low rate of recidivism. In other words, can't you make the argument that the system, though it seems draconian in many particular instances, is working because they're not offending? And if you took away some of those measures, you took away the sex offender registry, you took away those 4 cops who came to check up on that one individual at his home, if you took those things away, could it not well be the case that we would see those rates of repeat offending go up because now you've taken away those extra measures?
It's a really interesting and good question, and it's an empirical question, and it turns out that it has been studied. So the question you're asking is, what is the effectiveness of the registration notification scheme? Is it actually helping to reduce recidivism? And the answer, you know, there's been a number of studies, but in my mind, one of the most interesting studies was done by a couple of economists, University of Michigan, and they studied, I don't know, 19, 20 states. They did time series. They kind of looked at when these laws came in and what happened to the recidivism rates. And here's what they found. They found that actually there's an association between these laws and increased recidivism. And here's the reason. Recidivism, first of all, the norm actually is for sex offenders who've been caught and punished not to commit another crime. But in part, that depends on reintegrating with society and having the kind of support and control that goes along with reintegration. And if there's one thing that's clear, it is that these laws, particularly when they are draconian, these registration notification laws, they impair reintegration. Sometimes to the you know, extent of making people homeless. That's not at all unusual. But even when they don't go to that extent, they impair people's ability to have support from their family, to have jobs, to have stable housing. And all of that, at least according to these scholars, contributed to a statistical association between more draconian registration notification laws and increased recidivism. So
let me just
go ahead.
I'm sorry. No, I was just going to add to that you have to keep in mind that internationally, the United States is an outlier. We are the only country that has a routine public website of listing people who've committed sexual offenses. Other places don't do that, and they don't have higher reoffense rates. So, you know, take Canada, right? Our next door neighbor. They don't have public registries. Their reoffense rates are not higher, and if you look at the Western European countries, you get the same result. People don't reoffend there any more than they reoffend here, even though they don't employ all these restrictions.
Well, do you believe then that these, you can call them draconian or extraordinary extra measures imposed on sex offenders, actually has the opposite effect, that it actually, as I think, Eric, you were just saying, inhibits reintegration into the community and creates a greater risk than, which is not the desired effect, obviously, creates a greater risk of repeat offending. Would you go so far as to say that?
Yeah, well, that's what the study that I'm quoting from, that's what that study found. Again, statistical, empirical observation. So you can't say it obviously about every person, but when you look at it at a on a society-wide basis, that's the finding of that particular study. And let me also mention one other thing. So, you know, a kind of a corollary of some of these registration laws are these residential banishment laws that we've been mentioning. And those also are criticized for impairing or impeding the reintegration effort, obviously. I mean, they make it hard for people to find housing or stable housing. Now, the interesting thing about those laws, is that there are a score of studies, many of which have been conducted by law enforcement agencies, that recommend against residential banishment laws. There is not one study that I'm aware of, not one expert in this area of law enforcement or sex offender treatment, who says these are good, these kind of blanket exclusion laws are a good policy. Yet they keep being enacted. So there's little reason, in a sense, to give the benefit of the doubt to these laws. A lot of the laws are based on the notion that if we can save one life or save one victim, they're worth it, no matter what the cost to other people is. And I understand that sentiment, but in fact, there's a lot of reason to think that the net effect of the laws is not only ineffective but counterproductive.
Well, it's sort of like people whose view is we shouldn't give terrorists who stand trial in this country rights because they're terrorists. I mean, their crimes are so heinous. Who says they even deserve the same rights? But if we're not serving the intended purpose and actually creating conditions where people may commit more horrible crimes, then that ought to be reason enough to sit up and pay attention to this, I think. So, Ira, if you're advocating for a more individualized approach, I take it that necessary to that would be more resources to the mental health side of the equation. Just as you wouldn't want to release someone from prison on a drug charge and not have provided any drug counseling and treatment. I mean, big surprise if that person ends up going back into the community and repeating using or selling drugs. I mean, I would think that the mental health counseling, therapy, assessing, and follow-up would be extremely important to the view that you would bring to this problem.
Yeah, well, we actually officially do that. How well we do it, of course, is going to vary from locale to locale. But when people are released from prison as felons, whether they're sexual crimes that they committed or some other felony, they typically go on a parole regime in which they're supervised. And when their crime is a sexual offense, in most places, there's a required therapy program that they're supposed to participate in. That's one of the conditions of their parole.
Yeah, but is that an ongoing requirement? Is that usually an ongoing requirement? Because I know that often someone may be required to do a years-long course, for instance, or a year-long program. But just as these sex registries or these geographic restriction laws may be imposed on someone for many years, or even in some states for life, is the requirement for ongoing therapy typically part of the parole plan?
Well, it's usually ongoing as long as the parole process. It can end earlier. I mean, I'm most familiar with the federal system, in which the federal government provides that therapy. It requires participation in it. At some point, the therapist may conclude that it's not needed anymore, but that point does not usually come, before a few years at least. It may be more than a few years. So I guess we're already doing that some. We could do it better. There are places that I'm familiar with where the therapy programs are not at all good, may even be counterproductive. That's just a question of implementation. But in lots of places, they are, I think, helpful. And a lot of that therapy program goes, I must say, a lot of what people talk about in these group therapy sessions is coping with the burdens that are being imposed on them by virtue of the public identification as a sexual offender in trying to get themselves reintegrated into society. And so because that, of course, will make their reoffending less likely if they can get reintegrated, if they can get housing, if they can get employment. If I just go back on Eric's point about save one child, it's an important point, and an aspect of that is that all the burdens on children that are created by these laws, including banishment laws. A fellow who had a case in Illinois that I was involved in, he had a conviction. I mean, he'd been out, I think, 15 years or close to that, Illinois, and was for just looking at images. And I say just. He had possession of images of minors that he'd never offended, and all the time he was out. He had a 7-year-old daughter. He had a wife and a 7-year-old daughter, and he had to pull her out of school because one of his neighbors, opened a daycare center. You know, took care of some of the other neighbor children. Had to get a license for that. That triggered an Illinois law that required him to move because that neighbor was too close to him. So he has to pull his little girl out of school and move her to another school. Then another neighbor in his new neighborhood a while later did the same thing. He had to pull his little girl out of school and move her to another school. That happened 3 times. And there he is trying to, raise a family. And this poor little girl, for nothing she's ever done, has to be yanked out of school multiple times. Wow. That's not helpful.
Right. Well, we don't often think of the family of victims and the family of perpetrators too. I mean, that really is an important point to think about. So Eric, help us wrap up then. We've talked a lot about the problems. What would you like to see? And I know there's probably far too many specific situations that we could think about and suggest different ways that it could be handled. But as an across the board way of thinking about this problem, let's say, how do you think if we can raise people's awareness on this issue, how do you think we ought to be thinking differently about it? How should legislators and judges be thinking differently about this situation?
Yeah, I think that's the best question to ask. The key question, we have to change our way of framing this. What we've been asking all this time is, who are the dangerous people that we can move away from ourselves? We need to be changing the question and asking, how can we prevent the most harm? And it turns out that our focus on recidivism is misplaced. Not only are we wrong about it, but recidivism itself is a tiny part of the problem of sexual violence. 95% of arrests for sexual offenses are people who aren't recidivists, didn't commit an offense before. So we got to redirect our attention. Many people say we got to have it further upstream. And a lot of experts say that we need to be treating this like a public health problem. Public health approach means think about root causes, think about comprehensive programs, think about evaluating effectiveness and figuring out what programs are effective and replicating them. Base your programs on science and empirical knowledge, not on reaction and fear. That approach, that public health approach, is what I would say we need. We need a combination of primary prevention. We need a focus on the tried and true correctional measures that we know work. And then if we're going to do something more, it's got to be directed at people who are truly dangerous, not an undifferentiated heterogeneous group of people who have, on average, a very low risk.
Okay. Ira, did you want to add anything to the points that Eric made just as we wrap up?
Yeah, I think he's really hit the most important points, and that 95% figure is one that's often forgotten. While people are all focused on trying to contain or control or restrict those who've committed an offense, they're not paying attention to where the danger really lurks, which is first offenders. 95% of the crimes. That's
incredible.
Really,
well, I want to thank. I want to thank both of you. Really, thank you so much for. I've learned so much, and my brain is churning thinking about all this, as I'm sure it will for our listeners. If it's all right with you, both of you sent me a couple of articles that were very helpful to me in gaining some background on this for this conversation. If it's okay with you, we'll put links to those articles in the description for this episode, so people can take a look at those, get some further scholarship, some further background information. Fascinating reading on a really fascinating and, yes, controversial issue. But I want to thank my guests, both of them, Ira Ellman from the University of California at Berkeley, my hometown, and Eric Janus, a professor of law at Mitchell Hamline School of Law in, is it St. Paul or is it Minneapolis, or doesn't it matter?
It does matter, and it's St. Paul.
I think I just stuck my foot in my mouth for all Minnesotans out there. I'm sorry.
Wait, is Philadelphia in Delaware? Yeah.
Fair enough. Touche.
Okay.
Touche.
All right. Thanks, Aaron.
Well, thank you both. Thank both of you so much. I really appreciate it.